In Unocal Corporation versus Mesa Petroleum, the Delaware Supreme Court upheld the right of corporate takeover targets to protect themselves if the target's actions were reasonable in light of the threat and the response was in the corporation's best interests. Shortly thereafter, the court considered takeover defense mechanisms adopted by corporations that weren't immediately under threat in Moran versus Household International Incorporated, which we'll call Household. Household's board of directors sought to protect itself in what was then a dangerous takeover climate. Household hired corporate consultant firms Wachtell Lipton and Goldman Sachs to examine Household's vulnerability and recommend protective measures. The consultants formulated a preferred share purchase rights plan, providing that a tender offer seeking at least 30% of Household's common stock, or a single group or entity acquiring at least 20% of Household's common stock, would constitute a triggering event. This would entitle Household shareholders to certain rights. Shareholders would then have the right to buy shares of the offering entity at a discount price. If a merger or consolidation were to occur, Household shareholders could also buy shares of the offerer's stock at half price. This latter right was called the flip-over provision and worked by diluting the value of the aggressor's targeted shares. The board wasn't facing an imminent takeover threat, but adopted the plan as a defense against future takeovers. Representatives of both firms attended Household board meetings to fully discuss the plan and answer questions. The board then voted 14-2 to adopt the plan. John Moran, one of two plan opponents, was also the chairman of the Dyson-Kissner-Moran Corporation, which we'll call DKM. DKM was Household's single largest stockholder. DKM hadn't initiated a takeover attempt, but the plan made any takeover far more likely to fail. Moran and DKM sued Household. The Chancery Court upheld the plan. Moran appealed to the Delaware Supreme Court.